Good morning, everyone, and welcome to another TPN webinar. I am Rowan Terry, legal counsel here at TPN Credit Bureau. What we are doing today is a legal Q&A webinar. We have been asked by you guys for so long, from all the feedback forms, to rather have a session just answering your questions and questions about anything, any legality. So join with me today. We've got Greg Mason, our head of legal here at TPN Credit Bureau. Hi, Greg.
Hi, Rowan. Thanks for having us.
And joined with us as well is Claire Laurent, legal manager at SSLR Incorporated.
Hello.
Welcome. Thanks for coming, guys.
Thanks.
So just before we get started, because we have plenty of questions already, and I'm sure it's going to be very busy. So I'm going to get right into it. But before we do that, I just want to say, please will you make sure that you guys are all logged on to your YouTube channels, and you can put any questions you have in the live chat. It is going to come right here to me, and then I will ask them and we'll be able to answer them. Any questions that do not get answered, please make sure to email them to legal@tpn.co.za. Well, then, guys, I think we can get right into it.
Yeah, let's go for it.
Our first question is, I'm looking for the simplest least contact method and least costly method to ensure that the tenants pay their rent timeously and also in full. What am I legally required to do should they not pay the rental? I think, Greg, do you want to maybe take this one?
I'm happy to jump in. Okay, so effectively, the best thing that you can do is make sure that you act in terms of the legislated timeframes. So if you're using the TPN lease agreement, the rent is due and payable and must clear in your bank account by the 1st of the month. If it doesn't clear on the 1st of the month, you are perfectly entitled and within your rights to send a letter of demand to that tenant on the 2nd. Being strict with your timeframes is a really good way of ensuring that you stay on top of your tenants and that they pay you timeously. So you send your letter of demand on the 2nd, and then by the time that letter of demand expires, you can then send your notice of cancellation, and if they fail to vacate, then SSLR will be able to take over and start the eviction process. Just on those letters of demand, if you have a fixed term lease against a natural person, you're going to give them 20 business days in terms of time to rectify their breach, and if they don't, then you are within your rights to cancel that agreement on the 21st day. If they are a large juristic entity or your lease is on a month to month, then it would be a 7 calendar day letter of demand. But if you've ever got any doubt, then just get in touch with us first, legal@tpn.co.za, and we'll make sure you're sending the correct letter of demand to make sure that you're properly on top of your tenant.
Absolutely. And I think what I can just say from my side, a lot of legal queries, we have agents and landlords phoning in to say, look, this tenant is just giving me so many excuses. He asked for a week and then he asked for another extra few days. Rather just send your letter of demand out on the 2nd, and then they'll have that entire time period to then pay. Get your legal process going. Don't accept any excuses. Rather get it started, and then you're not going to have any delays later on.
And as you say, be proactive. Once you've sent that letter of demand, then you can have a discussion with the tenants about whether or not they're going to pay within certain timeframes. But your letter of demand can still be ticking over in the background. There's nothing to stop you doing that. If the tenant then at some point during that time pays in full, that letter of demand falls away and it doesn't affect the tenant in any way, shape or form. So you make sure you are proactive with your steps. Don't rely on the tenant.
Yeah, absolutely. And then we've got another one here. I have adversely affected my ex-tenant for non-payments. What other recourse do I have to get the payment? Claire, you maybe want to discuss?
Yeah, so I think a default credit listing is definitely a brilliant place to start. Your options then, also if we want to be as cost effective as possible, would be, I would definitely recommend the Rental Housing Tribunal in each province. And in my experience, my dealings, the turnaround time is a lot quicker than launching litigation in a court of law, and actually far cheaper. The beauty of approaching the tribunal is that the parties have an opportunity to mediate the matter. And if mediation fails, the matter is then referred to arbitration, where a ruling is made, and that ruling in terms of the Rental Housing Act actually holds the same weight as that of a magistrate's court. So it allows you to basically issue or execute on a money judgment perhaps that was obtained the same way you would if you had appointed attorneys to carry a summons for you in the magistrate's court. So I'm a big fan of the tribunal.
Yeah, and also if there's if the amount that you're claiming is less than 20,000 rand as a threshold, they also have the option of the small claims court if maybe if you maybe prefer for whatever reason to not go to the tribunal, if you've just been there before in the past and maybe you don't want to go there again, then you also have that small claims court as an avenue available to you if it's a smaller amount. But if it's over that 20,000 threshold and that's not available to you, then absolutely the tribunal is the place to go.
Absolutely, yeah.
Fantastic. We've got one here that says, kindly advise should a tenant vacate and repairs are required, how long does the landlord have to refund the tenant back, the remainder of the deposit?
So this is something that people get confused about quite a lot because there's a lot of dates that are knocking around in the Rental Housing Act. So quite often people might refer to 7, 14 and 21 days for returning deposits. But each of those have a very specific requirement behind it in the Rental Housing Act. So if your tenant leaves and you do your inspection, there's no damages at all, then you have 7 days from when they vacate to give back the deposit. But that's very clearly for that point if there's no damages. If you're dealing with a situation where the tenant fails to appear at the outgoing inspection, that is when your 21-day time period comes in, but that doesn't tend to be used all that often. You're usually going to either be 7 days if there's no damage, or if there are damages to the property, that's when 14 days comes in. And one thing to be clear on here is it's 14 days from the rectification of the property. And that can be interpreted to mean once that damage has been repaired. So you're within your rights to, as soon as reasonably possible, get invoices, carry out the repairs, get the receipts. Remember that your tenant is entitled to see those invoices and receipts for the work that has actually been done. And then once that work has been rectified and completed, then you have 14 days to return the deposit or what's left of it after you've deducted those repairs from that deposit. I hope that clears that up.
Yes, definitely. And I've also got a bit of a follow-on question here.
Absolutely.
If a tenant moves out overnight and left the keys at the property, can you as the agent do the inspection without the tenant, and what are the steps? And I think something that's very important here is that you can do the inspection without the tenant, but you need to ask for the inspection to happen. If you have not done that, if you've gone ahead and done the inspection without notifying the tenant, not having the tenant present, or at least giving them the opportunity to be present, then that will be deemed that there are no damages in the property without the tenant being present, and you will be obliged to return the full deposit and any interest thereon, regardless if there are any repairs at all. So it's very important that often there are times where a tenant can't make an outgoing inspection. Make sure that you have told them the time, try and organize it with them to have them there, because if you just don't organize it, unfortunately you're going to lose the entire deposit.
And make sure you keep evidence of that as well. So you make sure when that tenant vacates, let's say they vacated last night and you're trying to get in touch with them today, send them an email, a WhatsApp, take screenshots, make sure that email is saved somewhere for evidence purposes. Then you act in terms of your processes. You go and do your outgoing inspection as though you would. You note that the tenant failed to appear. You make sure you still take all your photos. You note all your damages. You follow your processes. And then if this ever ends up at the tribunal or some other avenue of trying to claim back that money, you've got all that evidence that you did your best to get them to attend, and it was because of the tenant's failures that they didn't attend.
Yeah, and I think what's important in this question is that's the case even if the tenant has just absconded. You still have the obligation to reach out to the tenant and invite them to your exit inspection.
Yeah.
Great. Then guys, one of the ones we get quite a lot, what penalties and or charges can a landlord apply if a tenant wants to terminate the lease agreement early? And I think something here just to touch on quickly is obviously if Section 14 of the Consumer Protection Act applies, the tenant will have an opportunity to cancel the lease agreement early on 20 business days notice, and you can impose a penalty, an early cancellation penalty that will be determined in your lease agreement. For instance, in the TPN residential lease agreement there, we have a section where you're able to say not less than a certain amount of months and not more than a certain amount of months. And according to the repeated findings of the Rental Housing Tribunal, a reasonable penalty would be no less than 1 month and no more than 3 months.
And I think it's important to note as well that this comes from regulations to the Consumer Protection Act. I think it's Regulation 5 off the top of my head, but I might need to be, I might need to be kept honest on that one. So that sets up a whole load of requirements that need to be taken into consideration when determining whether or not your cancellation penalty is reasonable. So one of those things is the industry norm and the industry standard. So because there's been so many cases where reasonable cancellation penalties have been determined either by courts or by tribunals, we can see in those repeated findings that the times that Rowan put of not less than 1 month, not more than 3 months is applicable. But you have to always look at it on a case-by-case basis. So if after 1 month you manage to find a replacement tenant, or even if you manage to find a replacement tenant by the end of that 20 business day period, then that might be something that greatly reduces your rental. So it's not a one-size-fits-all approach where just you're going to fall neatly into this block and that's it. You need to be very careful with your actual case of what happens and what amounts you can charge them for. Something to be very clear on is that you can't profit from the tenant cancelling the agreement. So the amount that you charge as a cancellation penalty, or the landlord charges as a cancellation penalty, cannot exceed the actual losses that have been incurred.
Fantastic. Then just on that as well, we've got a specific question here from one of our viewers. They have asked, if a tenant pays a year's lease up front, what happens if they terminate the lease during the fixed 12-month period? Is there a clause we put in the lease agreement addressing this?
So this is a very, very common situation that poses a great deal of risk to your landlord and you as an agency. It is so, you almost get excited when you hear, oh, I'm going to get the entire rental paid up front for 12 months. That's fantastic. Yeah. But as you've touched on there, if 4 months through the agreement, the tenant now gives their early cancellation that they've referred to earlier, and you charge, let's say, 1 month as a penalty, then you've still got 7 months or 6 months, whatever it is, of rental that you have to refund to the tenant. The fact that they've paid them up front doesn't mean that you've provided the service for that entire period of time. So you must be very, very careful that the landlord doesn't go and spend all the money that they've received on the rental. One method, which I do recommend, which is something that you can include as a special condition in your mandate, perhaps, is that the rental can be retained by the agency and paid out monthly to the landlord, just to make sure that they don't go and spend all the amount up front. Also make sure in your agreement that you specify in the lease that payment is going to be for the 12 months up front, and be very careful to make sure that you include something that says what's going to happen with utilities, because utilities might not be paid for 12 months up front, they might still be owed monthly, and now you're still building arrears even though you've got all of this rental paid out. So you don't necessarily need additional clauses as standard in your contract to cater for that, because it's not really too common. So include it in the special conditions section, send it to TPN Legal, we'll have a look at it, make sure that it's correct, and then make sure in your mandate with your landlord that you cover how that money is going to be dispersed out to the landlord.
Fantastic. Then it seems that our inspection question, the outgoing inspection, was actually quite popular amongst a lot of you viewers, because there's quite a few sub-questions that we've been getting here as well. So let's start addressing a few. From Ingrid van der Merwe, can you do an ingoing inspection without the tenant present?
So you shouldn't. In terms of the Rental Housing Act, it says that those inspections must be joint inspections. So the tenant, if they at a later date, let's say you don't give the tenant an opportunity to appear at the ingoing inspection, at a later date when if it goes to the tribunal, they're disputing the outgoing inspection findings, you need to have a proper record of what damages were there at the incoming inspection point, and the tenant had a right to be there. Tribunal might throw out your claim and ask you to send back the entire deposit to the tenant based on them not appearing at the ingoing inspection. I know it is sometimes practice that what people will do is they'll say, oh, tenant has 7 days in which to point out all of the damages in the property after they move in. But that's not built into the legislation. You have to act in terms of the law, which requires that joint incoming inspection.
Perfect. And then also just the legalities around not having an ingoing inspection. You know, if there is no record of what the damages were when the property took, when the tenant took occupation of the property, you won't be able to hold them liable for any damages, because there's no record of what damage was caused by the tenant or was there existing when they moved in. So it's so important to make sure that you do your ingoing inspection and have the tenant there, just as Greg has said. Mariska Pulse has asked, what does the law stipulate regarding interest earned on deposits? Claire, I don't know if you want to...
Great. So The Rental Housing Act provides that your deposit must be invested in an interest-bearing account with a financial institution. It does happen on occasion, especially where landlords are not assisted by a property practitioner, that they don't do that. Then, I mean, you are then in contravention of the Act. The tenant also has a right to request proof that that deposit has been invested. If after the fact it comes out that the tenant didn't actually, the landlord didn't actually invest the deposit, what then happens is we need to say, well, no harm, no foul. Let's add what interest the deposit would ordinarily have accrued over that period if it were invested in, say, a savings account. So that's basically what the legislation calls for there.
And your tribunal is going to pick an amount that would have been as interest that's probably going to be on the higher side of what savings accounts would have accrued. So if you actually have a savings account and it is incurring an actual rate of interest, that is the rate of interest that you pay back.
Right.
You're going to do yourself a disservice because the interest rate that is ordered is going to probably be higher than what it would have been if you'd actually kept it in that savings account.
Sure.
Yeah.
Perfect. Then on this one here, we've got the question, and it's come up quite a few times, of what happens if, with paying back the deposit, but your final utilities account only comes back after a time period where the deposit needs to be legislatively returned. What happens in that kind of situation, and how are we able to give some advice to our viewers?
I actually wanted to raise that sort of when you were talking about the 14-day period from date of restoration. And I would argue that restoration shouldn't be interpreted solely to mean actual restoration of the premise itself, but also to ensure that all monies that are due to the landlord, including the last month's utility charges, are paid. I know in practice sometimes we do a estimate amount, but technically until that municipal account is received, there would be 14-day period from there to refund the balance of the deposit.
Absolutely. And what you see in practice, I think you touched on it there, is that if, let's say, it's been 1,000 Rand every month pretty consistently, then you can return the deposit but keep back 2,000 Rand.
Yeah.
Something like that. Just to give yourself a little bit of a buffer. The tenant still gets part of their deposit back, and then after you get that final municipal account, you deduct your 1,200, slightly increased, then you've got that extra.
Yeah, because at that stage you would know then this is sort of what we estimate we're going to hold back.
Yeah.
And at that stage it's best to refund the undisputed portion of the deposit to the tenant.
Perfect. Then we've got from Chantal George. When doing a move-in inspection and the tenant refuses to sign the inspection, what is required of the agent to manage this challenging tenant?
So you can still carry out your inspection as though you would anyway. Complete it. Now remember that photographs alone is not an inspection. You should also have an inspection document. There is one available in the TPN residential lease pack. Download it and use it, please. And you can note there that you attended, you give your signature, and then where the position for the tenant is to sign, you can perhaps sign on their own behalf and say tenant refused to sign the incoming inspection. Make sure that you've got your evidence that you were there. If you can, you are able at a later date to do an affidavit stating that the tenant was appeared at the inspection and that you signed stating that they refused to sign. A tenant would be committing perjury if they said that they didn't attend. So you have that option as an affidavit to put the facts in place.
Perfect. And we've got a question that came through. How do you calculate the interest on the deposit if the landlord did not invest that deposit on there? And I think that's more of a question for your accountant to assist you there, to be able to help you calculate the interest. I don't know if we have.
Yeah, they could perhaps go and look at a few of the major banks, have a look at what their normal interest interest rates would be. Take the one that's in the middle.
Yeah,
and
it's usually 3-4 if I'm throwing out numbers, but have a
somewhere
look at what.
Find the sort of middle ground of what a reasonable interest rate would be, and you go with that. There's no legislated process of how to deal with that situation because the legislation says you have to have it in that account.
Yeah.
They don't account for if you fail to meet the legislation.
Fantastic. So we also got one here. How do we deal with a tenant that has been given notice and vacates the property on the 15th of the same month? and they want the pro rata rental back for the 15 days plus their deposit. Is this, how do we deal with this situation?
So the tenant's been given notice.
Yes, yeah, to vacate at the end of the month.
Right, so there your landlord has an expectation of a tenant for that entire month. So regardless then, and that's not to say that parties can't reach their own agreement, but legally speaking, I would say that for that last month's period, they're liable for the full month based on the fact that a full calendar month was given, and the landlord had the expectation of a tenant for that full month. So even if then the landlord can gain access to the property earlier, perhaps start repairs, it doesn't change the position.
I agree with you completely. You've given a specific notice period.
Yes.
The fact that you have chosen to say vacate without notice that you're going to be leaving earlier doesn't take away from that notice period that is in place.
Yes.
Yeah, tenant will be liable until the end of that notice.
And that notice period was agreed to by the parties in the lease agreement. So,
Exactly.
yeah.
Fantastic. Then Claire, a question here we've got, if an owner rents out his property and the tenant has a child or is pregnant, that you cannot kick them out even if they haven't paid, would the owner need to find alternative accommodation and pay for the first month's rental of that accommodation?
Yeah. So there's a couple of misconceptions, I think, when it comes to evictions, especially residential evictions, where the Prevention of Illegal Eviction from an Unlawful Occupation of Land Act, that's a mouthful, what that basically says with regards to the personal circumstances of your occupier. So courts are constitutionally obliged, and in terms of legislation, to take into account the personal circumstances of the occupiers, and most notably the three categories of vulnerable persons that are identified are children, minor persons, women-headed households, and elderly persons and disabled persons. Sorry. So while that, it very often happens that there might be a pregnant woman, but those are purely circumstances for the court to take into account in determining a date on which to grant an eviction. So it doesn't act as a defense to an eviction, and furthermore, there is no obligation whatsoever on any landowner to provide alternative accommodation. This is a responsibility that rests solely on the shoulders of the governments and municipalities. So and that is why we actually cite the municipality to our eviction proceedings in the event that the court makes a determination that there is a possibility of homelessness, that the municipality be called to produce a report setting out whether they qualify for emergency alternative accommodation, and also whether such accommodation can be made available to them.
Yeah, there's a very important clause that we included in the residential lease quite recently, which is a alternative accommodation address that your tenant will provide you at the outset of the lease agreement. The point of that is not, and we get questions about this a lot, of why it's in there, and it really is to help the eviction attorneys. So if they provide you with an alternative accommodation address, say for friends or family or someone along those lines, it tells the court when they read the papers that they do have another address that they can go to. So when you're filling out that agreement, if they genuinely don't have another address to go to, then you're going to be able to leave that out. But if they do have family, friends, someone that they can rely on to go to that alternative accommodation address, it does make it easier when you do the eviction to get that eviction order. In fact, it just might be pushed back a little bit on the final date that the court says that they can stay in the property for.
Absolutely.
So make sure you've got that in your lease agreement if you haven't already.
Perfect. And I think while we're talking on court action, we can now touch on, there's been a few questions on it, the infamous S word, spoliation. I don't know if, Claire, you just want to explain what spoliation is?
Okay. So spoliation, or in Roman Dutch law, it's called monument van spolie. And basically that's a remedy which someone, in this case a tenant, invokes if they have been dispossessed of property. So commonly that refers to lockouts, disconnection of electricity or water services. It may also include disconnection of a remote or gate access if we're talking about a body corporate. And then if we want to talk about extreme, removing doors and windows. And I mean, we've all encountered.
Heard the stories.
So, right, so, you know, and it is seen by the courts as an act of self-help. So you might feel, oh, but you know, the landlord is so desperate because he needs to reclaim his property, he's not receiving any rental income. And sure, you know, we can feel for him, but the landlord has to act within the four corners of the law. So I'm moving, what you actually asked, what is spoliation? So it's actually just the dispossession. And what's important, dispossession, even if they're an unlawful occupier, if their lease has been cancelled, and if they haven't paid for, call it months, if you still can't take any action which has the effect of dispossessing them of that belonging, because the only requirement for a tenant to prove spoliation, or that he was spoliated, was that he held possession, whether lawfully or not, basically.
Yeah. And then also just building on that, would it, obviously I know the answer myself, but does it apply to commercial leases? On a commercial lease, are you entitled to you know, lock the doors?
It does depend very much on what you have in your agreement, but if you have, and there has been some cases that maybe go about it, but you need to be very, very, very careful.
Absolutely.
The overarching principle here is that no person may take the law into their own hands.
Yes.
There are processes in place, you know, there's the sheriff of the court, there's courts, there's the police. You make sure that you follow the correct legal processes in obtaining a eviction, commercial or residential, to get the tenant out of the property. Never take the law into your own hands, because it is considered a criminal act. You could potentially find yourself getting arrested for doing things that are outside of the law. So if in any doubt, come speak to attorneys. Don't just act first and then ask questions later. Always ask the questions
because
beforehand.
The effect of acting without asking the questions might land you in, as Greg said, potentially being arrested, but also the tenant's automatic remedy there would be to approach a court, and they have grounds for urgency, meaning they can be in court as early as the next day. And you know, because it's the nature of an urgent application is so in depth, you know, attorneys are entitled to charge a lot more for an urgent application. And unfortunately, if you are found to have spoliated, the court will in all likelihood grant a cost order against you, which will set you back even further. And then you're sitting with a cost order and having to institute a lawful eviction. I don't recommend it.
Absolutely. We've got a question here from Home and Equity, just on the whole spoliation question. Can you block a tenant's third-party prepaid meter, water or electricity, if they are in arrears? I think, Claire, you also touched on this earlier, that that would also constitute a spoliation. So you would not be entitled to do so.
And so so sometimes it's, especially if the tenant has a separate contract with the prepaid meter. The prepaid meter, that contract may provide that if they don't service, say for instance an arrear, they might be able to use a portion towards, so what they might do is apply 50% towards the arrears and 50% towards electricity. But that is a question, that's then a relationship between the tenant and this provider.
Exactly.
Fantastic. We've got quite a few questions here on this one. Is what happens if a tenant doesn't want to move out on the agreed date and the new tenant has made payment and is ready to move in? They've arrived at the property with all their belongings, their beds, their fridge, everything, and the tenant doesn't want to leave. What do we do in this situation? Greg, you seem very eager to answer this question.
So effectively, the tenant that is going to be moving in is going to have a very large damages claim. They are going to be able to seek alternative accommodation, all the cost of moving their belongings into storage. All of that is a claim that they are effectively going to have against the landlord, because that's who their contract is with. But all of that damage that is suffered is damage that the landlord is going to have to recover from this outgoing tenant. The actions of the outgoing tenant is what has caused the damages to occur. So that is going to be almost a chain of debt that's going to accrue. It becomes very difficult for the landlord, and obviously they need to go to SSLR very quickly and start the eviction process of getting that tenant out.
Absolutely.
And the new tenant that was meant to be coming in is going to be racking up a lot of damages in the interim. So they need to be very, very careful.
Yeah. And I think on that, if there is a situation like that, we would, cause a letter to be sent and specifically advise that not only are, they looking at an eviction, but potentially also damages suffered by the landlord as a result of the tenant's failure to vacate the property.
Yeah.
And I think often what happens there is that, agents and landlords, they don't really communicate this to the tenants. They just say, you need to be out, that's it, that it's done. If you could actually, before anything, sit with your tenant and go, look, these are the ramifications of your actions, and this is going to cost you so much more money.
Don't do it.
Don't do it. Exactly that. So just also, I think having an open communication channel with your tenant at all times is definitely the best.
Definitely helps. Yeah.
Yeah. With regard to the interest on the deposit, should the full interest amount be paid out to the tenant?
Sorry, can you repeat that?
With regards to the interest on the deposit, should the full interest amount be paid out to the tenant?
Yes, it should be. So this is maybe something that caused a bit of confusion in the industry with the changing of the Property Practitioners Act versus the old Estate Agency Affairs Act. So under the Estate Agency Affairs Act, it was mentioned in the Rental Housing Act that there was an option to either pay it out to the tenant or for it to be split 50-50 between Estate Agency Affairs Board and the agency. But when the Property Practitioners Act came into play, the Estate Agency Affairs Act no longer existed. The Rental Housing Act wasn't updated to say the Property Practitioners Act instead of the Estate Agency Affairs Act, so that portion of that clause fell away. So effectively, the only clause that's still available is that the deposit is distributed to the tenant. So on the TPN lease, you'll notice that the block to tick where it would say that it would be distributed to the agency and Estate Agency Affairs Board, that has been removed.
No longer.
So yeah, it needs to be dispersed to the tenant.
Fantastic, thanks Greg. Then I think we've got a few maintenance questions. We've got if there's let's say for instance there's a burst pipe or a burst geyser and there's a very high water bill. Who is responsible for the account? Landlord or tenant or both? The account was increased in this particular situation by over 2,000 Rand.
So what's very important here is to note who is responsible for the damage that's occurred. If it is, as you say, a burst pipe or a burst geyser, that's generally going to be something that is considered fair wear and tear because it's not something that was in the tenant's control. If the tenant is gardening and puts a spade through a main pipe and it's negligent and that's what caused the burst, that's going to filter into who's liable. So if it's fair wear and tear, then the damages that come from that damage, like the burst geyser, those will be for the landlord's account. So what you need to do there is work out an average consumption. You still charge your tenant for what the consumption would have been. You're not going to have the whole water bill being covered by the landlord. But then of that 2,000 Rand or whatever it is for the water bill, if you can work out that 500 of that was from the burst pipe, then that's what will be charged to the landlord. But if it is negligence, then the whole bill will be for the tenant's account.
Fantastic. Thank you so much, Greg. Then to all of our viewers out there, the feedback form has been posted onto the live chat. You can just click on the link in order to fill out the feedback form to get your attendance certificate for today's training. We've got so many questions here, guys. It's quite.
Thank you for sending them all through.
Thank you.
This has been what you've requested, and all of the webinars that we've had. It's always, I wish there was more time for me to ask questions, and we want to be able to, help give you the answers that you're looking for. So thank you for tuning in today as well.
Yeah, I think with the amount of questions here, there's enough we could probably do a Q&A webinar every day. I mean, we would be exhausted, but that's what
it would be worth it.
We have got one question here. The property is transferred from one agency to another. Is there a legal obligation on the previous agency to supply the new managing agent with a copy of the ingoing inspection if the tenant was inherited?
Absolutely there is. So something to be very mindful of is that all of these documents that you have that relate to a lease agreement, That is a document that you have because you are the authorized representative of the landlord. The landlord is obligated to have all of these documents in terms of their relationship between themselves and the tenant for the lease agreement. If the landlord's authorized representative changes from one agency to another agency, that agency is entitled to hold those documents because the landlord is entitled to hold those documents. So it's not a case of whether or not you should, you must provide those documents.
Yeah.
Because it is the landlord who is your client, who you are holding them on his behalf. They don't belong to you. So yes, and the same goes for if you're holding a deposit. The deposit should also be transferred to that new agency, as long as you have all the valid proof in place that there's a mandate, that they are who they say they are, that the landlord has confirmed that that is my new agent, then yes, you need to work with the landlord, who is the person obligated in terms of the legislation, and make sure that you provide it to their new authorized agent.
Fantastic. Then we're just going to pop back one question because we've got a follow on there with the burst pipe. And if the burst pipe had happened, but your tenant didn't report it or notify you, and because of that, now the damage is so much worse. In that scenario, the tenant would have acted negligently, and the tenant would be held liable for that damage. So if you are able, your contractor is able to go out and ascertain that actually this has been here for a while, and it's, if we had been contacted a while ago, it would be a quick little solve, but now we have to, redo everything. Then that a cost would be for the tenant's account specifically.
And I mean, that comes up a lot with a leak.
Leaks, yes.
Yeah. So, and then you sit with a huge water bill as well.
Yeah.
So they can definitely be negligence assigned to the tenant for failing to bring it to the agent's attention.
Yeah. If a tenant should reasonably have foreseen that was causing additional damages, that reasonableness is the measure of what is negligent.
Yeah.
So if a reasonable tenant would have reported that there is a leak and it's very noticeable and they failed to carry out their duty, then yes, as you say, they are responsible for the cost of those repairs.
Yeah.
All right, then we've got from Renter Roof Reps, if the lease is end or being breached and the tenant denies access to the property for viewings to take place, so that you can obviously get a new tenant when they're going to move out, can you then withhold the deposit from the tenant if it will be a loss of income for the owner?
Yeah, I get this quite a lot, and it's a difficult one because especially if the relationship is soured, and which is not always the case, but if it's at the end of the lease and tenant is being difficult or refusing to grant access for the purposes of viewings, then the landlord sits with a problem where he absolutely can't advertise the property to get a new tenant, and is then going to suffer loss of rental income in the event that that's not done. So what we usually do as attorneys, will address a letter to your tenant to say you have unreasonably refused, and the TPN lease does obviously make provision for it's a responsibility of the tenant to make the property available for viewings. Then we say you are refusing, and as a result of your failure, you will be held liable for any damages suffered, and it might be even, I like that, to say we're going to use the deposit, and that might actually cause them to come to the party.
Yeah, I mean, if you are holding amounts on behalf of a tenant, and there are damages that are suffered, there are abilities to do set off of amounts. You do need to be careful that you note that this claim that you're making can potentially also be separate from the lease. It's a damages claim based on the actions of the tenant, but because you are holding funds on their behalf, you can set them off against.
Yeah, and then I think
damages.
If the tenant had an issue with that, they could approach a court or the tribunal to say, well, I don't agree with the offset against my deposit.
Yes.
And then they have the opportunity to make their case.
Yeah, and you as a landlord have a counterclaim to that claim that they want their money back.
Yeah.
You counterclaim and say, but they owe me X, Y, Z. So no.
Yeah.
Perfect. Then we've got a question here from Charlene Peterson. We use the e-signed TPN contracts, but get so many complaints that we did not discuss the content with the tenant, like the bank charges or the breach of contract penalty, etc. What can we do about this?
Okay, so they're all considered reasonable contract clauses. What the Consumer Protection Act requires is that if there is a clause in a contract that's ordinarily deemed to be abnormal, let's say. So if it's something that wouldn't ordinarily fall into a contract and it is in there, then that you have a duty to explain. But things that you described there, payment of bank charges, reasonable cancellation penalties, everything that is in the TPN lease agreement is a ordinary clause in terms of the industry and is generally accepted. So on e-sign, one thing that happens is that you can't sign the agreement unless you have gone through all of the pages. And the only place to click sign is at the very, very bottom of the page. So in getting to that button that you click to sign, you must have gone through all of the pages of your agreement. So the duty is on the tenant to familiarize themselves with their lease. You don't have a claim to say, oh, I didn't read my lease, therefore I can't be held liable to it. Everyone has a duty to read every contract that they're entering into. So yeah, nothing in the lease is outside the normal scope of a lease agreement, and a tenant has a duty to ensure that they familiarize themselves with the contract that they're entering into.
Yeah.
So by clicking that sign button and filling out your electronic signature, that is a valid and binding contract.
Yeah, and, in jurisprudence we would call that caveat subscript, or Latin. So that's a Latin word for be careful of what you sign.
Yeah.
But Greg, what about the Ask TPN? Is that available on the...
It is, I believe. So as you go through the lease agreement, at the top corner of any of the clauses that are there are options of a link that you can click, and it will direct you to the TPN website onto a wiki page, and it'll give you a full description of the contents of that clause. Thanks for bringing that.
Cool.
Fantastic. Then we've got a mandate question here. In the case that a client has purchased the property as an investment property and takes over the lease, is the original agency obliged to hand over to the new owner and their agent? So in this respect, you've concluded a mandate agreement with the owner of the property, the current owner, and he's giving you authority to manage the property on your behalf. When he no longer owns the property because the property has been transferred, it's been sold, that mandate agreement is automatically terminated and you are no longer the managing agent, unless, of course, the new owner has come to you and you've signed a new mandate with them and to continue. So you would need to give all of that documentation to the new owners.
Exactly. You can try and speak to the old owner to have a conversation with the new owner and, give you a good recommendation and say that this property, you've managed it well. You can, please try and conclude a new mandate agreement with the new owner. But yeah, as you say, Rowan, that old mandate ceases to exist on transfer of the property. So you must get new mandate from the new owner in order to manage that property.
And that's distinct from the case where your lease agreement, where we all know hier gaat voor koop, that means that the lease supersedes the sale. So if it was purchased for an investment, like you mentioned in the question,
Yes.
that lease agreement will carry through. And we often get asked if there needs to be a new lease signed, if there needs to be a session of the lease. And the answer is no. It's luckily a case of the new owner stepping into the shoes of the previous owner as the landlord. And it all happens by operation of law.
Yeah, it's automatic. You don't have to change anything. If you do want something written down, you can do a lease addendum or something like that, just where the parties acknowledge that the landlord has changed. But in terms of legality, it's not necessary at all.
Fantastic. Then a question we've got is, what actions can you take against tenants that break the house rules regarding noise? Neighbours complains that they are very noisy at night. If you guys don't mind, I think I'll take this one.
Yeah,
when it comes to house rules, they have to be attached to the lease agreement as per subsection 8 of the Rental Housing Act. That in order for the rules to be binding on the tenant, it needs to be attached to your lease agreement. And then once that's done, you would be able then to hold them liable for noise complaints and issue fines as per the house rules.
Thank you.
Great stuff. There is plenty here.
Thank you. There seems to be a lot of questions coming through.
Yes,
definitely
yes.
appreciate
Greg, on mandates. Does
Yes.
one need to complete a new mandate every time you place a new tenant? Or can you have a mandate that just continues until the landlord cancels it?
So a mandate ordinarily operates together with a lease agreement. You're mandated to enter into a lease agreement on behalf of the landlord with a tenant. So theoretically, when that lease agreement comes to an end, so does your mandate. So you should have a new mandate signed for each new lease agreement that you're doing. And the same, so something to note as well on that is that when a lease is renewed, that renewal is taken into account with the old mandate. So you don't need to do it on every renewal with the same tenant, but if that tenant leaves, that lease ends entirely, and you go on to a new lease agreement, or you're given authority to find a new lease, then you should get a new mandate agreement. This also is very helpful because it allows you to get your mandatory disclosure form in place.
Yes.
And if you don't get a new mandate agreement every time there's a new lease, you operate based on an old mandatory disclosure form. So it's good to get that updated and keep that in place. Absolutely. And up to date.
Absolutely. So we've got Sonia Smith said, if the rules, so this is back to the house rules question, if the house rules are sent separately, will this still be accepted? We do have proof that it was sent. So obviously for purposes of sending agreements electronically, you can attach the house rules. Just make sure that your tenant has just initialed those pages to show that they have gone through them and that it's attached, and also label it as Annexure A to the lease agreement.
Yeah, you need to be very, very careful here. So as an example, you can't enter into a lease agreement, the tenant moves into the property, they take occupation, and then a week later you send on the house rules to them. It doesn't work like that. The Rental Housing Act, as Rowan pointed out, is very specific that it must be attached to the lease agreement. So if you send the house rules in the same email that you're going to send a lease agreement, if you're going to do it with a wet ink signature, say, send those documents together. When you get your mandate agreement from your landlord, at that point, ask for a copy of the house rules for if it's a body corporate complex. Make sure you have them in advance. Act proactively, not reactively to when the tenant asks for them. It's very, very important that it is attached to the lease. Otherwise, you cannot bind the tenant to the conduct that's expected for them by the body corporate.
Fantastic. Then we've got the question here from Rental Roof Reps again. If the mandate has been signed by the owner, is there a clause that you can sign? Is there a clause that you can sign the tenant's lease on the owner's behalf? Sorry, I got the question there. And that would not be a clause within your mandate agreement, but it would rather be a power of attorney that you would need to complete, where the landlord would then give you the power to sign any agreements on their behalf, and where that is included in our TP and lease pack as well.
Great.
Exactly. Fantastic. Then there was a question that I saw that was really fantastic, but now I seem to have completely...
Just while you're looking for that, make 100% sure that your mandate agreement alone does not give you that authority. Even if you put clauses in there that say, yes, you have that authority to do so, that special power of attorney is a standalone document and something that courts will look at very specifically when determining whether or not a valid lease agreement was created. So that special power of attorney, if you haven't gone and looked at it, even if you're not going to use it right now, just go and look at it and see what it says, because it also needs to be very specific that it is for the signature of the lease of that property with that tenant.
Yes.
So
Fantastic. Then I managed to find the question. We had a rental housing complaint case against our agency for a procurement lease. The deposit was paid to the landlord in terms of the lease. The tribunal said that the agency should have kept the deposit in this particular scenario. I don't know if you have any dealings with the tribunal, Claire, that you are able to...
I feel like I've... Can I ask who
Natasha Vincent.
Natasha Vincent. Because I've just seen a similar thing, and maybe it's now becoming a common thing. But so the TPN lease does provide for especially if it's a procurement, for the deposit to be held by the landlord or by the agency. So yes, obviously in a procurement, it's ideal if the agent holds the deposit for the duration of the lease period, and then come the termination, the parties can either agree to terminate or to perhaps renew the lease. But it is very much a possibility for the landlord to hold the deposit. This would be the case, and it is what the Rental Housing Act provides for. So there I would have said that, and with respect, that the tribunal might have erred in that finding. On the back of that question, the particular agent that was speaking to said, well, they said the tribunal had an issue with the fact that it was initially paid to the agency and then paid to the landlord. So practically speaking, this is done so that the agent can deduct the procurement commission from the first month's rent. The balance is then refunded together with the deposit to the landlord if that's what the parties have agreed. But so my argument there is it's not a question of who it was paid to, but rather it's who it's held by. And you'll see the lease makes specific provision for who is the deposit held by.
Fantastic.
Exactly. It could be on a case-by-case basis like that as well. If you've got an agreement in place that says that the agency is going to hold it, then you could make the argument that you need to comply with that lease agreement. So when you're filling out your lease agreement, make sure that you are not just ticking the same boxes every time you fill out the agreement, that you actually are taking cognizance of what has been agreed in advance and what you're putting into your lease agreement. So if it is a case that the deposit is going to be held by the landlord, in your lease agreement stipulate that it's going to be held by the landlord, and then you shouldn't run into difficulties as long as you're compliant with what you've agreed in advance.
Sure.
Yeah, it's always on a case-by-case basis.
Then from Danielle Posnack, we've got with renewals, if the rent increases, the deposit should also increase accordingly. May the interest already earned be used towards the new higher amount?
Yeah, this is completely down to agreement between the parties. So theoretically, yes, when your rental amount increases, your deposit top-up can be requested, and you should put in place, if you are going to use the interest that's already accrued towards that deposit top-up, when you are filling out your addendum, make sure that that is stipulated, that the interest is being applied to the deposit top-up. You don't want to run into any sort of confusion down the line of the amount that's been accrued. So make sure you've noted everything in the paperwork.
Fantastic. Then we've also got again from Danielle Posnack. How would a tenant put an owner on terms should maintenance be needed, but the owner refuses or drags their feet?
All right. So the lease will provide that in the event of the landlord's failure to perform his obligations in terms of that lease agreement, which includes, maintenance and possible repairs. If the landlord is then, you can have a polite conversation, an email, please attend to this. If the landlord is then dragging his feet, as Danielle said, in terms of that lease, the tenant must place the landlord on terms by issuing a 20 business day letter of demand and specifically affording him that period in which to attend to the repairs. If the tenant forgoes that very important step and decides, I've had enough, I'm going to cancel the lease based on the fact that you are just dragging your feet, well then the tenant is exposing themselves to a penalty. So that penalty will apply regardless of whether the landlord was in breach or not, unless the tenant has actually given that 20 business day letter of demand. He cannot cancel without penalty.
And what we obviously see quite a lot, which is very clearly illegal, is that you'll have tenants that haven't read that clause in their lease agreement properly, that they need to place the landlord on those terms. And what they'll decide to do is just withhold the payment of rental until such time as that that gets sorted out. But very, very clearly, two wrongs don't make a right. You cannot breach your lease agreement because you feel that your landlord is in breach. And the same goes for the opposite way around. The landlord can't say, tenant hasn't paid the rent, therefore I'm not going to do any repairs. Everyone is required to comply with their responsibilities in terms of the agreement. Simple as that. So tenant, yes, you place the landlord on terms 20 business days to rectify any damages, and landlord as well, you place the tenant on terms to rectify their payment of rental. Yeah.
Fantastic. Then Greg, with just a blacklisting question, could you maybe just give us just the requirements of blacklisting and what needs to be met before an owner can blacklist a tenant for non-payment of rental?
Of course. So adverse listings are very, very regulated, and it's regulated in Regulation 19 of the Regulations to the National Credit Act, and it does set out the requirements that are there very clearly. So the first requirement is that you must have given your tenant 20 business days notice of your intention to load that adverse listing. bear in mind that that is the same regardless of whether it's a month-to-month lease or a fixed-term lease. It's not the same as a letter of demand in that sense. You still can send a 7-day letter of demand, but you must wait the full 20 business days before you load the adverse listing on the tenant's profile. The second requirement is that the account has been in arrears for a continuous period of 3 billing cycles. A lot of the time, people confuse that with you must have missed 3 rental payments, which is not the case. The way it works is that the account as a whole must have been in arrears. Whether that's in arrears for an entire rental amount or whether it's in arrears for a smaller amount, that is something for determination on a case-by-case basis. Those are the 2 requirements, and if both of them are met, then you have the ability to load an adverse listing on the profile. If, for example, you send out the 20 business days notice of intention to list, that's in the form of a letter of demand. If that letter of demand is paid in full, it falls away. Again, like a lot of other things though, if in doubt, get in touch with us, legal@tpn.co.za. We will make sure you are ready to load the adverse listing before it goes on the account.
Absolutely.
Something very important to note is that you only get one opportunity to load that adverse listing. You get one bite of the cherry. If you get it procedurally incorrect the first time, it's gone. You don't have the option to do it again.
Yes.
Then we refer you to attorneys to go get a judgment, and that judgment can be loaded on a profile for a more extended period of time.
Yes.
But yeah, adverse listings, they are technical, so make sure you fully are understanding how to do it before you load it. And if in doubt, get in touch with us with your specific case and we'll help you through it.
Absolutely, and we have actually got, we've recently released a guide to adverse listing. It's on our TPN blog. You can go on there. It provides all the information you would need. And then obviously legal is available to be contacted should you have any further questions. And on that as well, there's a lot of questions on deposits that we've been touching on for quite some time. There's also another article there on rental deposits demystified. So the answers are there as well. Really, I mean, if you just go onto the TPN blog, you can really find any article to assist you. Then Claire, just before we finish, I think we have about time for one more question. What is the average cost for an eviction?
Okay, well, do you see how my...
Yeah.
No, well, it is dependent from attorney to attorney, but I would say position yourself that you appoint attorneys who specialize in evictions. It is it's an involved process, and it requires a appreciation for the PI Act and also litigation. So if it is that you would need to go the whole hog in obtaining an eviction order, usually we charge 25 to 30,000 rand. SSLR specifically, we charge deposits as we go. This is because we can sort of see that an eviction follows more or less the same trajectory. So if we're doing a phase 1, which is a cancellation, it's a set fee. If then we've cancelled and the tenant refuses to vacate, we can then move to phase 3. Then at your phase 3, if the tenant does vacate, we can then refund a portion. So we sort of go along with it, and our goal is to get the tenant out as soon as possible.
Yes.
So if we can avoid going to court, that's the goal. And it does happen, I would say, almost 60% of the time that the tenant will vacate after the lease has been cancelled, or then after the sheriff has served even higher. And there's those few cases that we would have to actually bring a full eviction, and then we deal with it, as best we can. And there you would need an attorney who knows what they're doing.
Yeah. I think something that's important for you to note as agents when you're explaining to a landlord the importance of doing an eviction properly is it's not just about how much you have to pay for the eviction. It's about how much you're losing by having a tenant in the property who's not paying rent. If you've got a 10,000 Rand rental and you're not doing the eviction and you're trying to do things and it's not working, and you go 4 or 5 months and you've got a 10,000 Rand rental, you've lost 50,000 Rand. Whereas if at the very beginning you started the process early and you went through your eviction, you can limit your losses by paying that amount of money. So it's all about perspective when you're looking at evictions. It's not just about the bill that you have to pay at the end. It's also about how much you're losing by having a non-paying tenant in your property.
Fantastic. Well, that is unfortunately all the time we have for today, but thank you, Claire, for joining us, and thank you, Greg.
Thanks. I enjoyed that.
To everyone, please just remember, all the viewers, thank you so much for joining us. There's been such amazing questions and comments. Obviously, we haven't been able to get to all of them, so please just make sure that you fill out your feedback form to get your attendance certificate, and then also you can email legal@tpn.co.za. And until next time, thank you.